Um, good afternoon, everybody. My name is Jeff Prang. I'm the LA County Assessor. I think this is the first time I've had the opportunity to present to Keller Williams Larchmont, and I'm really glad we found some time to get together. And thank you, Paula, for helping put this together. I did want to state right up front that my very first job right out of college was as a real estate agent back in my hometown of Warren, Michigan. I wasn't very good at it, which is why I'm in government now. But such experience has proven invaluable as I work along with so many other friends and colleagues in real estate. And I'll do the best I can do to liven up today's meetings with an exhilarating presentation from the LA County Property Tax Assessor. So for those who are not familiar with it, my office is responsible for the valuation of all taxable property in LA County. I am not the guy who collects taxes. I am often identified as the tax assessor. I don't do taxes. I'm just the assessor. The guy who does taxes has a very intuitive title. He's called the tax collector. Our job is to assess all property, all taxable property, which includes real property, which is land and buildings, as well as business personal property, which is furniture, equipment, machinery, as well as aircraft, boats, mobile homes, and believe it or not, even racehorses. My office is the largest local property assessment agency in the United States. We're responsible for valuing over 2.5 million real property parcels and business assessments annually. In many ways, the assessor's office is the most important local government agency because we are essentially the fiscal engine of local government. No other local agency, whether it be a city or school district, can do their job until we've done ours. And if we don't do our job completely and thoroughly, then the property taxes, which should be identified to go into vital public services, are instead left on the table. As you can see on the screen, the property tax system is relatively complicated, and the assessor is only one piece of the larger operation. There's several departments that we work closely with, and each one of them owns a different piece of the property tax administrative system. The two primary departments that we work with are the auditor controller, as well as the treasurer tax collector. And the way it works is we get a copy of the deed from the registrar recorder or a building permit from one of the cities. We then determine the value of the property. We then turn that data over to the auditor controller. The auditor controller is the one that determines how much taxes you have to pay with the, it applies all the rates. They then turn that data over to the treasurer tax collector, who mails the bills and collects the payments. The primary job of my office is the production of the annual assessment roll, which is essentially the inventory of all taxable property in the county. And we operate on a fiscal year that ends June 30th. So we are in the height of our busy season right now, as we're trying to complete all of our work before the end of June. The assessment roll serves a number of purposes. Obviously, it's the base for determining property taxes for the county, but it also serves as an important planning document for local governments as they use it to prepare for their budgets in anticipation of property tax revenues. And it also serves as an economic indicator for the general community, providing some insight as to the health of the local real estate market. That said, last year's assessment roll represented the 11th consecutive year of countywide property growth. Total value of the assessment roll grew by almost $63 billion, or a 3.7% increase over the previous year. The total value of all property in 2021 was more than $1.7 trillion. I just released a press release just a couple of hours ago announcing that we are forecasting that property values for the current year will have grown 6%, almost double over last year, and that the new total assessed value of all property in the county is just shy of $1.9 trillion. Obviously, this is important because these property taxes pay for vital public services that we all rely on, such as schools, roads, hospitals, libraries, etc. The factors that were contributing to the growth in the forecast include the strength in the transfer of property, especially housing, as well as the annual cost of living adjustment of 2%. That's the maximum allowed under Proposition 13 Last year, CPI was only 1%, so the 2% indicates tremendous strengthening of the real estate market. Business personal property, that's furniture, equipment, et cetera, showed a modest dip in value. And while new construction did see an increase, it's roughly half of the typical growth we've experienced in pre-COVID years. To give you an idea of what's going on locally, I've included a table that displays property value growth percentages. These numbers are still based on last year's numbers, since we won't complete our work this year till, as I said, till June 30th, after which we'll have some more updated numbers. But as you can see, a number of cities in your service area, including West Hollywood, Culver City, City of LA, all experienced well above the county's growth of 3.7% last year. The total 2021 combined assessed value for all the cities that you see on this chart was over $793 billion. And we see no reason to believe that these trends will not continue with an upward trajectory. I know it's no news to any of you that the housing market in LA County has experienced over 2 years of record highs. Housing prices have increased so much that $1 million homes as a median sales price have become the norm in more than 50 cities and neighborhoods throughout the county. I've included a chart here that gives the median sales price for single family homes, not including condominiums, in the city of LA and some neighborhoods adjacent to their service area. And as you can see, every place is well over, except for the county average, is well over $1 million, with pretty strong growth. Beverly Hills property values, median sales price increased by 22% last year. Moving along, one of the things I wanted to talk about for a moment were tax savings programs. My office, while we are not the revenue department, we do manage a number of programs to help people save money on their property taxes. We have programs for seniors, veterans, the disabled, nonprofits, amongst others. Last year, we helped taxpayers save about $650 million in tax savings. The one I wanted to emphasize today is the homeowners exemption. Homeowners exemption is available to anybody who owns their home and occupies it as of January 1st. It allows me to reduce your assessed value by $7,000 for tax purposes. It is not a huge savings, about $70 a year, but it's a one-time application. And we estimate that 1/3 of all homeowners in LA County don't apply, primarily because they don't know about it, leaving about $30 million of savings unclaimed every year. I like to emphasize this with realtors, because I know a lot of you do email marketing and direct mail marketing and offering tips on property tax savings. I thought might be something you would want to include in your outreach. I'm sure prospective clients appreciate the opportunity to save money where they can. Moving on to the next topic, I want to talk a little bit about Proposition 19. I'm sure you're all familiar with this. It was adopted by the voters back in November of 2020. It was sponsored by the California Association of Realtors. Prop 19 does two primary things. The most popular component that was really the emphasis behind the measure allows homeowners who are over 55, severely disabled, or the victims of natural disaster to transfer their property tax base with them when they sell their home and buy a new one. It expands the benefits that existed under the previous law, and it allows a qualified homeowner to buy a home anywhere in the state to transfer that property tax base up to 3 times, 6 times if you're married, and you could transfer that tax base to a home of any value. The second component deals with the transfer of property between family members, specifically between parents and children, and in some cases, grandparents and grandchildren. This part was not very well known when the measure was on the ballot, primarily because it greatly reduces the property tax benefits that existed under the previous law. So Prop 19 has, as it relates to interfamily transfers, does a couple of things. One, unlike the previous law under Prop 19, the only property that your children can inherit from you with your tax base is your primary residence. The previous law allowed your kids to inherit your home, and that home could be of any value, and it would not be reassessed, and it allowed them to inherit up to $1 million in value on additional properties, such as rental property. But under Prop 19, the only property now that qualifies is your primary residence. It also places a cap on the value of that residence So if the rule of thumb is that if the home is worth less than $1 million, there will be no reassessment. If it's over $1 million, as it is all of the west side, there's going to be a tax change. It'll be a blended rate. The inherited rate up to $1 million will be blended with the market rate for that over $1 million. So that it won't be a market rate increase on the property taxes, but will be a upward adjustment. And we've put a lot of information on our website. We created a special page for Prop 19, as well as a couple of tools for base year transfers and intergenerational transfers that can give you an estimate of what the new property taxes will be in those cases where there will be an adjustment. Finally, I didn't want to miss an opportunity to call your attention to our newly designed website. One of the things we do on our website is we have a special tab for real estate professionals, which is designed with realtors in mind. We put a lot of information on that site that'll help you with your professional development, information that we think you might want to share with your clients. We also issue a quarterly newsletter designed specifically for realtors. I urge you to bookmark this page and feel free to copy and paste anything in there to share with your in your marketing activities or whatever else you may need reaching out to your clients. So in closing, I just want to thank you for the opportunity to be here to visit with you all today. Any of the information I talked about today is my staff can provide to you, including our slides. If there's anything we can do to be of service, hope you'll reach out to us. My contact information is here on your screen, and I'm also going to put it into the chat. And if it's appropriate, I'm happy to answer questions at this time.
I'll start since I was the one that wanted you to come. Thank you for coming.
Really?
I'm an agent in this office, and I get a lot of questions from my clients related to Prop 19, both good and bad. Everybody is focusing on the fact that people can take their property tax basis with them. I have recently come into a situation where a son was on a deed with his mother because his father passed away in 1999, and he is grown, doesn't live with her anymore. He still helps her out, but he doesn't live there anymore. So in order for her to take advantage of Prop 19, he decided to just give her back his half of the house, and that triggered a reassessment to the point where they actually have to sell the house because they can't afford the reassessment because they've had the property since the 80s. They're trying to get that reversed. But is that something that you can speak to as to a situation where people could avoid these pitfalls?
So I don't think that sort of transfer is typically a reassessable event. Nicole White Gamble's on the line with us. She's kind of my expert on ownership issues. Nicole, that doesn't sound like it should have been reassessed. Am I missing something?
Good afternoon, Assessor Prang. In the past, with the old rules with Prop 58, a parent and a child could transfer the property back and forth amongst one another, and they could actually file for the exclusion. In this instance, I think what's happening is the son transferred his portion back to his mother, but it sounds like he does not live in the house. It wasn't his principal residence.
Yes, that's true. He had just essentially inherited his father's share when his father passed in 1999, but he wanted his mother to be able to take advantage of Prop 19 and get the full benefit of it rather than just half, if she chose to move from where she was to be closer to him. So he transferred it back to her, and the entire property got reassessed in a massive way.
Right. So in this instance, this is one of the differences under the rules under the new for the parent to child transfers. I'm assuming that when he transferred the portion back to his mother. He did it after February 16, 2021, when the new Prop 19 rules came into effect. Having said that, looking at it, if the mom had some interest in the property, it should have only created a partial interest. So in that regard, only his interest should have been reassessed. But if this had a very old base year, I could see how that could still be very significant. So there may be some more they need to look into our office, but for the most part, that is a big difference because of the new requirement that someone actually does have to live in the property.
Yeah, okay, and we have I've connected him with an attorney who is trying to help him through that. But it does sound like that's correct. And I think most of the agents on this call, that's not necessarily what they're facing, but I think an understanding of that flip side of the, what we'll call a negative impact of Prop 19 is important for people to know.
I think I need to state very, very clearly that Prop 19 provided a lot of benefits for those who are 55 years or older, gave you a lot more options to moving. But to tell you, Prop 19 put the screws to family inheritance. It really did. It's reduced the benefits and is causing a lot of frustration with a lot of people. Because I don't think people were really aware of the trade-off that was being proposed in the measure.
Yeah, that's why I brought that up, because I think it's important that people know both sides of it. Another question that comes up for those that are over 55, that comes up for my clients a lot, is if a couple is married and they have a house, say in Los Angeles, maybe they've had this house for 20, 30 years, the kids are grown, the grandchildren live in a different part of the state, and they want to downsize into a smaller house, stay local, but into a smaller house, but then also buy a second house, again, smaller, but closer to the grandkids, say whether it's up north, down south, wherever it is. Would they be able to buy those properties as individuals, split that basis? If they're a married couple, one buy one house, one buy the other house, so that they could take that cost basis, or at least half of it, they could each take half of it with them and buy two homes instead of just one.
Oh, that's a nuance I had not encountered before.
I get asked this regularly.
Nicole, I don't think they can do that, can they?
They cannot. So when you're transferring a base value, that base can only go to one home. So it would be their primary residence. It does not give you the ability that you have two owners and they take that one base and put it onto two properties, even if they're both of equal or lesser value. It can only go to one home.
And in the case of divorce, how would that play out?
It did. Yeah, I'm sorry, Assessor Prang.
I was just going to say, in interspousal transfers, whether it be getting married or getting unmarried, are not reassessable events. They're excluded.
And only one of them would be able to use that base to transfer to another home.
Thank you. That probably comes as a shock to a lot of people whose over 55-year-old clients are getting divorced.
There's a couple of notes. I get a lot of questions, typical questions I get asked when I speak to realtors a lot. I'll just answer some questions that haven't been asked yet because they might be helpful. But one is deals with the death of a property owner. When a property owner dies, the heirs of the estate are required within 150 days to notify my office that there has been a change in ownership due to the death of the property owner. There's a form that must be submitted called Change in Ownership, Death of Real Property Owner. Failure to file that within 150 days could complicate inheritance and other estate planning issues. It's also important to remember, adjacent to that because your property is in a trust, does not eliminate your obligation to take care of these administrative steps, such as filing that form, or in the case of inheritance, filing Prop 19. Trusts are simply a set of directions as to what's to happen with property upon the death of an owner, but it's not an autopilot. There's still things that have to be done. We get a lot of calls from property owners who get reassessed because they didn't understand what those rules were. Another thing that comes up a lot is if you're doing new construction or if you're building an ADU, they want to know how that property would be reassessed. It's important to remember we do not reassess the entire property when you do new construction. We just assess that additional square footage. And then finally, you'll oftentimes discover that there are discrepancies between records that the assessor has and records that you might see in a city's building safety department. And the question that always comes up is, whose do you believe? The cities, the city building and safety or community development. Those are the official records. The city is the one that determines what could be done on property. We will assess what we see and what we know to be there. We don't opine on whether it should be there or not. So typically, if there's a discrepancy in records, that usually is an indication of unpermitted construction that had come to our attention. But because it's on our records and not the city's records, doesn't make it legal. The city is the one that determines what can be done on property. But
can I address what you just said about trusts? We live in a high value area, obviously, as you know, and there's a lot of estate planning that goes on. I mean, when the median price in Beverly Hills is $8 million a house, I think it's assumable that people have more than living trusts. They have irrevocable trusts. They have family limited partnerships. They have all sorts of holdings of the way they hold property. So say it's a property that's held in an LLC. The LLC is owned by a variety of trusts. If someone within that entity either gets removed or it dies, is that a trigger for reassessment if the ownership of the property, i.e. the LLC, or the trust, and I don't mean a living trust, I mean an irrevocable trust, the dynasty trust, if somebody who was a beneficiary involved in that passes away, is that a reassessable event?
like everything else that we do, the operative phrase is, it depends. So, and Nicole is more familiar with trusts and LLCs and some of the nuances of those transfers. I'm going to call on her to walk us through that question as well.
So Charlotte, you actually mentioned several different ways of methods of holding title. And so, like Assessor Prang states, it always depends. And of course, we have to look at the very specific situations for each of those. But I will say this, generally speaking, if you're talking about a legal entity like a corporation or an LLC, generally speaking, when there's any kind of majority change in interest, then there is a reappraisal. And there's so many nuances to that. I don't want to go too much more than that, though. So even though the name of the LLC or corporation may not change, we have to look at really what the holdings are underneath that, who has shares, et cetera, to determine whether or not it'll be reassessed or not. So that becomes really important. But generally speaking, when any person or there's a change in control, which means a majority share now has transferred, that's what happens with those. When it comes to trust, those are different. And there's a whole other set of rules. But generally speaking, we have to look very closely at who are the beneficiaries of that and who's the trustor. So it's very specific in terms of how those documents prepared and how things are held. So there's no blanket statement, but I would say generally speaking, as a rule of thumb, people should anticipate that when they have these type of changes, they can result in a reassessment of the property, either in its entirety or a portion thereof.
There's a question in the chat so directed to me. It says, I owned a lot privately. I privately sold. The sales price was $21,000. The assessor assessed it at $210,000, and the buyer had to struggle to get it reduced. The actual sales price. So, not knowing all the conditions on that question, let me answer a little bit more generically. So, the sales price is not necessarily the assessed value. The Prop 13 requires that when property changes hands in a transfer or a sale, that we assess it at market value. Typically, people pay market value as the sales price. So in the overwhelming number of cases, we accept the sales price as market value and will enroll that. Typically, if you told me you sold a lot for 21,000 and we appraised it 210,000, the appraiser probably had some reason to believe that that value was much higher than it sold for. There are a number of steps you can take to challenge that. It sounds like that's what's happening. You can call the appraiser and give them information as to why I think they were wrong, or you could file an appeal and have a hearing officer, the Assessment Appeals Board, adjudicate that. But that is a pretty significant $200,000 difference is pretty significant. I don't know why that would have been the case, but if you want to contact me separately, I'm happy to have somebody look into that. Another question from Carlos Alvarado. He says, what's the process and formula for assessing new construction like an ADU, and how do you assess depending on location for a specific place? So for most residential property, we use the market comparable methodology to appraisal. We look at similar buildings that have sold recently and add and subtract based on different quality and other amenities. When you're building an ADU, we use the cost methodology, and we will examine the cost that you paid, but it's not necessarily your cost that determines what that value will be. It's regional standards, and we use a number of tools, including Marshall and Swift cost manuals, to determine what that will be. Another question: how backed up are you with Prop 19 applications? We are very backed up. I will be perfectly candid with you. Prop 19, as it was adopted, was a dumpster fire. It was unenforceable. We had spoken to, frankly, we spoke, California Assessors Association, spoke with the California Association of Realtors when they were drafting it, and told them that there was no way we could ever implement Prop 19 in the 2 months that the measure went into effect, but they put it into the measure anyway. As adopted, the measure was full of inconsistencies, ambiguities, and contradictions of law. We needed legislation to chase Prop 19 to clarify all those issues. That legislation didn't get adopted and signed by the governor until last October, months after the measure went into effect. We then had to wait another couple of months for the Board of Equalization to issue all the regulations and guidelines based on that legislation. So we did not even begin processing Prop 19 applications until until spring. So anybody who applied for a Prop 19 base year transfer last year did not get it processed. We didn't know how to do it. Think of it this way: somebody buys you a piece of furniture at IKEA, and they give it to you without instructions and with missing parts, and then tell you have 15 minutes to put it together because people are coming to use it. That's essentially what Prop 19 did to assessors. We've been struggling to implement this. We really needed about 18 months to change our technology, our workflow, and to the measure didn't give us any additional resources or personnel, even though it was a tremendous increase in our workload. We're doing the best that we can catch up. But one of the challenges we're having is, in some cases, in senior citizen base year transfers, because we haven't been able to process those applications like we would like to. Some of those people are getting supplemental tax bills for the new market value of the property. We will eventually get through these and they'll get their money back, but it has caused a lot of inconvenience for seniors, something that we regret. We're working as fast as we can, but we were really handled a boondoggle with Prop 19.
Hi, can I ask you, you just mentioned a few minutes ago about the discrepancy between permitted, unpermitted square footage of properties and also what's on assessors records. And since, like in real estate, we mostly, like that's how we also help our clients determine the market value of property. I'm curious, why is it the assessor's records are the public records for any property, and why is it not like the permitted, unpermitted square footage? And why isn't there a process that if someone applies and completes the process of renovation and addition of square footage, why isn't it automatically reflecting on assessor's records?
Well, under the Revenue and Taxation Code, all cities are required to give us copies of building permits and building plans so that we can ensure that, the way the system is set up, our records and the city records should be the same. But when they're different, that usually means somebody did something without a permit, or the permits were not transferred to us. They should be identical. Although one of the challenges we have in terms of maintaining accuracy of records is that there's 88 cities and a number of other jurisdictions throughout LA County where they do construction permits. They all use different systems. Some of them still do it manually with paper permits. Some of them do it electronically with a variety of different platforms. So it's not integrated between all these different agencies. Ideally, we would create a unified platform. Not all cities are able to pay for those, so it can be a little bit chaotic at times.
So to piggyback on Dragon's question, if we have a client, say, that bought a house at a certain square footage, but it was really bigger, the permits are there to add the additional square footage and they're signed off on, finalized. So it was permitted additional square footage, but it is not reflected on your records. Do they risk being reassessed for that additional square footage if they purchased the house that way?
Yes. So we again, there's some depends pieces in this one as well. So when there is new construction, we will assess that new construction. There are statute of limitations of how far back we can go, but if we learn that there was a major improvement done 3 years ago, we would go back and add that value to the assessment and issue an escaped assessment. But Nicole, in this scenario where the property just changed hands recently, and that new construction was already there, but we didn't have that on our records, how would that affect our assessed value?
Well, in this case, assessment, like you said, everything always depends, but we could probably look at what would be really important in this instance. Then you said it was permitted. So then in that case, there should be permits that were pulled prior to the sale of the property. And it sounds like you're indicating that the building and safety may have already finalized it. So once we knew that, that means any assessment that we made would be either to the previous owner, and as Assessor Prang said, it would be an escaped assessment. But then we would also understand that the sales price that's been reflected, it should have been indicated or indicative of the bigger square footage. So for the new homeowner, if all of the work was permitted and it was finalized prior to, we would know that we should be looking at that sales price and evaluating it based on that higher square footage that was already existing prior to them owning it. And so there shouldn't be additional square footage added, or I should say value added on top of the sales price. But we would have to look at it, and that's why all of those different timeframes become really important. It's usually more problematic when there's unpermitted new construction, because we are mandated to pick it up regardless of whether or not it's permitted or not. And then of course, at that point in time, we'd have to make a determination of when that work was actually done, either prior to the sale or after.
Thank you.
I don't see any more questions in the chat. Did want to say though, again, my contact information is in the chat bar. So if questions come up after we're done here, you're welcome to reach out to me or my team at any time.
I do have one more. I feel like I'm the only one asking questions. I'm sorry for that. I hope I'm not boring everybody. But in the case of our high net worth clients who are concerned about a property tax base of transfer, I'll give you an example. I have a neighbor who purchased her house little over 20 years ago for $800,000. She has an adult daughter. The house is probably worth about $6 million now. Her daughter, they would not be in a position to pay those property taxes. Is there any recourse, whether it's either estate planning or time or anything that can be done to their descendant, and somebody who inherits a property other than selling?
There's nothing that we have available, no tools that were made available to us. It is, Prop 13 is, or Prop 19 is pretty specific who qualifies and what the benefits are. So this is a concern to a lot of folks that if properties get reassessed, that they may be, that it may create a tax burden that is no longer affordable on their income. This has, particularly when it comes to additional property aside from your additional your primary residence. And I don't know that there is any other that there's anything available to lessen that burden.
I mean, that honestly makes sense to me, because I think that's I don't see it as a positive personally, but it makes sense because the lost revenue of people buying and selling when they're over 55 up to 6 times, and that lost revenue is being made up on the inheritance side. I realize that you're very backed up with these applications and everything, but is there really any is there any data on what that differential is? I mean, is Prop 19 actually going to generate more income than the old 60/90? Because I have heard rumors that there's a repeal coming on this.
So the repeal, the Howard Jarvis Taxpayers Association was circulating signatures to repeal the inheritance portion of Prop 19, but they didn't get enough signatures, so they'll have to start all over again. But we still don't quite know what the revenue impacts will be because we still have not fully implemented Prop 19. We probably won't know until about next year whether there's going to be. I think the local revenue generation component of it was probably greatly overstated, but we are finding a number of unintended consequences. One that I just heard recently was somebody whose parents had owned I think a 10-unit apartment building. They had a lot of long-term tenants, and when their parents died, and the property is now going to be reassessed at market value, and they said they can't afford the property taxes on the new market value of that property, and they don't want to pass along the increase in taxes to all their tenants. Some of them are seniors and people with modest incomes, but they conclude they have to sell the building because they no longer can afford the reassessed property taxes.
See, this is really, I guess part of what we do as real estate agents, or I can't speak for everyone on this call, is we help our clients build wealth through real estate. And the intention is to build generational wealth through real estate. And this is harmful to that goal. So the question that I have, I understand the turnover in property is greater, which is probably why Carr, wrote the bill. But the actual building of wealth for our clients sounds like it's there's a negative side to it. Do you have any advice, or maybe Nicole, as to how people, if they are acquiring, say, multi-unit properties, duplexes, rentals, whatever it is, that their intention is to build a portfolio of real estate for their children, grandchildren, et cetera. Is there a way that they should be holding that property? And I realize we're not lawyers and we should not be giving this advice, but being educated, I think, is important for all of us. Is there a way that they should be holding that property that would be more beneficial to that goal?
Well, I'm not a lawyer either, and my staff will always tell me not to give that advice. But I candidly, I don't know that you probably should talk to a lawyer who knows about different types of legal entity alternatives for holding property. But for the most part, if you own property that you want to pass along to your children, you can do that. They will get the asset, they will get the value of that asset. But those assets are going to be reassessed, and in most cases, and if they can afford to pay the change in taxes, they'll be able to inherit the property. And but otherwise, they may have to cash out to that may be the benefit that they derive, but they may not be able to keep the property if they can't afford the change to assessments. There's a number, in the corporate side, there are a number of legal entities that corporations use to avoid the transfer of property. I can't really speak to how that would be handled on a more family basis, but those are things that you may want to look into.
Or we just tell all our clients to get life insurance.
It's another option as well.
There was another question for you in the chat. I don't know if you saw it from Patricia.
Yeah, she was asking about the appeal of Prop 19, and as I was stating, there was an effort to repeal that portion of Prop 19 that deals with inheritance. They were collecting signatures. They didn't get enough signatures, so there's no longer an active measure to repeal that portion of it. There was the Howard Jarvis Taxpayers Association. They may try again. And somebody else says that you should. Prop 19 teaches us to read the measures before you vote for them. So I would say that handling complex property tax and assessment administration on ballot measures is probably ill-advised. It's extremely complicated, and just like we've seen on Prop 19, the senior citizen transfer was very popular, but they didn't tell you about the inheritance portion of it, which is what's paying for the senior citizens transfers. And so there's consequences I think people would have liked to have known before they cast their vote.
So Prop 19, my understanding is a 10-year proposition.
No,
Or is it permanent? It doesn't have to be renewed in 10 years?
it's permanent.
Oh, really? Okay. So I guess for the time being, without a repeal, we just tell our clients that they take advantage of it by being over 55, buying and selling, and I guess that's it.
It is the law until it's not. Until it's repealed.
Yes, Patricia, I agree with you. It was very deceiving.
Yeah, I was a little, I felt it was, I think they should have, in the campaign, they should have been upfront saying that we are increasing one set of benefits by decreasing others. And if people wanted to do that, that would have been fine. But I don't think they knew that there was this big of a trade-off. And I know it's a problem because I've probably spoken to thousands of people about Prop 19 over the course of the last 18 months, and there's a lot of anger about this portion.
Is there any indication? I understand that a repeal of this inheritance side of things allows the proposition to not be paid for. I do get that. So I could see maybe a repeal overall, going back to 60/90 might make some sense. But is there any talk of $1 million of being the only exemption of, your child wants to live in your house? I'm 54, so I don't plan on dying in the next 10 years. My son is 15, but say in 30, 40 years, he wants to live in the house that he grew up in. $1 million isn't going to cut it. Is there any indication that that number could change over time or increase?
I don't know if there's an escalator put into that. Nicole, is there?
There's a slight CPI escalation on that amount. So it's not CPI, but there is an escalator on it, but it's still probably small and close to CPI. Whether or not that increases more, Assessor Prang, like you had said, that was something that was put in the measure that people were trying to get on the ballot that was defeated. But there is a small escalator in that amount.
So it doesn't necessarily align with, say, that median home price, which is right now it does.
So no, yeah, so there, I'm forgetting it's not a CPI indicator, but it's another indicator that'll be utilized to trend forward. The other portion that would be protected is plus whatever the trended base value is, still very small. But it does exist, just to note.
Well, thank you. And I guess maybe a lot of us on this call might be willing to sign that petition to change that.
Well, I thank you all very much for the invitation to join you this morning. I'll probably have some update on market numbers available later this summer once we've closed the roll and done our analysis. Happy to come back. In the meantime, just want to remind everybody to check out our website, sign up for our realtor newsletter, and we're happy to be of service at any time you need us.
Thank you so much for taking the time.
My pleasure.
We all appreciate this.
Good to be with you.